Hi everyone. Just a reminder, we will be getting started a little bit after 6 so we can wait to see who else will join us. But thank you so much for joining us. Good evening again, everybody. I know it's 6 p.m. We'll give it another minute or so and then we'll go ahead and get started with today's presentation on the Paid Leave for All Workers Act, what workers should know. We just want to make sure we get started once we have enough people. Thank you. Good evening, everyone. We're going to go ahead and get started. My name is Lydia Colunga Merchant, and I'm the Leave Rights Division Manager at the Illinois Department of Labor. And I will be giving today's presentation on the Paid Leave for All Workers Act, what workers should know. So thank you all for joining us. We'll go ahead and we'll get started. So just a little bit of background on the Illinois Department of Labor. So our mission here at the department is to protect and promote the wages, welfare, working conditions, and safety of Illinois workers by enforcing state labor and employment laws, providing compliance assistance to employers, and increasing public awareness of workplace protections. And so we are a team of about 117 passionate individuals, and altogether we enforce nearly 30 different state labor laws. And that includes the minimum wage, the Illinois minimum wage law, which protects minimum wages and overtime, the Illinois Wage Payment and Collection Act, which protects unpaid wages and vacation time and bonuses and commissions, a number of different laws, and now we also are charged with enforcing the new Paid Leave for All Workers Act. So just some background on the act itself. So the General Assembly found that it's in the public policy interest of the state for all working Illinoisans to have some paid leave from work to maintain their health and well-being, to care for their families, or to use for any other reason of their choosing. So Illinois is one of only 3 states with a paid leave for any reason law. And citing directly from the act, the provisions of this act shall be liberally construed in favor of providing workers with the greatest amount of paid time off from work and employment security. So on the agenda for today, we'll be talking about the following topics. What is paid leave? Who is covered under the law? The types of paid leave policies, how to use and request paid leave, additional employee paid leave rights, how to file a complaint with our office, and then we'll end with a question and answer session. So at any time you can leave a question in the comments, but we won't address them until the end of the presentation. And throughout, hopefully, we tailored this presentation to try to cover different topics that we have seen since January 1st in emails and voicemails that we've heard from other workers and their questions. So hopefully the presentation will address those frequently asked questions, but if not, feel free to submit a question in the comments. So main takeaways we want workers to understand about this act. First, this is not a paid sick leave law. Instead, the state law entitles employees to earn 1 hour of paid leave for every 40 hours worked, up to 40 hours per year, to use for any reason of their choosing. So, this isn't just for sick days, it's for use for any reason at all. Also important to note, if your employer already has a paid leave policy that provides you with at least 40 hours of paid leave that you can use for any reason throughout the year, then your employer does not have to provide you with additional leave time. Also, note that you do not need to tell your employer the reason for using paid leave, and you do not have to find another employee to cover your shift in order to use that paid leave time. Also note your employer may be able to deny a specific leave request, but they must have a reasonable policy explaining why, and they must provide you with that written reason why they're denying the leave. So what is paid leave? So paid leave is the time that you take off from work and are paid without getting penalized for it. There are other types of leave that workers may have heard of and their employers may provide. So that can include sick leave, vacation leave, bereavement leave, personal leave. Some people may be familiar with the Family Medical Leave Act type leave, etc. And so this leave may be paid or unpaid depending on your employer or depending on the state law. We're using a couple of acronyms here on our slides. So wherever you see PLAWA, we mean the Paid Leave for All Workers Act. And wherever you see PL, we mean paid leave. So under the Paid Leave for All Workers Act, most workers are entitled to earn or accrue up to 40 hours of paid leave per year. And as we stated before, if an employer already provides their workers with at least 40 hours of paid leave before January 1st of 2024, their employees may not get additional time off because their employer has already met the requirements of the law. So I just want workers to understand this isn't, if your employer provides this, 40 hours of paid leave, it's not that your employer is exempt from the law. Instead, it's more that their policy may already be in compliance with the new act. So as we stated, what about those existing paid leave programs? So for example, your employer may already have PTO, they may have paid sick leave, they may provide paid vacation, they may provide you with paid personal days or comp time, etc. So again, the most important part is that you are able to use this leave for any reason of your choosing. So for example, if it's just a sick leave policy that has restrictions, you can only use it when you're sick, that by itself would not count for compliance with this act because you wouldn't be able to use it for any reason. However, if your employer has a paid vacation policy that provides at least the 40 hours of paid leave in a 12-month period that employees can use for any reason, then that would likely count. So who is covered by the Paid Leave for All Workers Act? So the Paid Leave for All Workers Act covers nearly all Illinois workers, and so it takes its definition from the Illinois Wage Payment and Collection Act. And employee means any individual permitted to work by an employer in an occupation. And so this includes full-time workers, part-time workers, seasonal workers, temporary workers, on-call workers, etc. If you meet that definition of employee under the act, then you are covered. Also important to note, if you are a domestic worker, you are also covered under this act. But if you're also a domestic worker who is an independent contractor, then you are also covered under the act. So who is not covered? A lot of questions we have gotten from other workers have been whether or not their employer is exempt or whether or not they are covered. And so the act itself has certain specific exemptions. And so that includes independent contractors generally, certain railroad and airline employees, certain higher education employees, union construction and freight employees, park district and public school district employees, and generally those workers who are covered by a union collective bargaining agreement would not be covered. Because again, you should just look at your collective bargaining agreement, which we'll talk about in a slide coming up. So what do we mean by independent contractors? So as I stated before, except for domestic workers, independent contractors are not entitled to paid leave under this act. However, just note that simply being called an independent contractor does not mean that you are in fact an independent contractor. Under the law, you need to meet 3 factors in order to be considered an independent contractor. And so that's 1, you're free from control and direction about how you're performing your job. The type of work that you do is outside the usual course of business of that employer, and that you are an independently established trade, occupation, profession, or business. And so in Illinois, if you do not meet all 3 factors, then a worker is likely to be considered an employee covered by the Paid Leave for All Workers Act. So what about union employees? So for those employees covered by a collective bargaining agreement, otherwise known as a CBA, that was in effect on January 1st of 2024, then the terms of the CBA will remain in place until the CBA expires. And that also means, like, even if your CBA does not provide any type of leave, whatever your CBA provides is what's going to control. And so again, if you're covered by a CBA, then the Paid Leave for All Workers Act is not going to cover you. However, when the new CBA is negotiated, the parties may negotiate the terms of any type of paid leave provided. But it's important to note that if the employer and the union do not come to any agreement explicitly and clearly waiving the Paid Leave for All Workers Act requirements, then the employer must provide at least 40 hours of paid leave to those employees. That's really important to note, that waiver of any Paid Leave for All Workers Act requirements have to be explicitly, clearly, and unambiguously waived. That's so that way workers know where they stand and what the requirements are under paid leave that their employer has to follow. So we have an example. So for example, the Hat Makers Union has a CBA with the Hat Factory that expires on June 30th. So the union and the factory are negotiating a new CBA that starts on July 1st. And so they both decide to specifically waive the Paid Leave for All Workers Act, and instead they agree to that the workers will receive 20 hours of paid leave and 30 hours of unpaid leave per year. And so because that's something that was negotiated and they specifically and clearly unambiguously are waiving the Paid Leave for All Workers Act requirements, then starting July 1st, the factory does not need to provide the 40 hours of paid leave as required under the act. So overlap with local ordinances. So if you're an employee who works in the city of Chicago or in suburban Cook County, you are likely covered by Chicago's paid sick leave ordinance or upcoming paid leave ordinance or Cook County's paid leave ordinance, and not the state law, so not the Paid Leave for All Workers Act. So if you have any questions about the Chicago ordinance, we ask that you contact the City of Chicago's Office of Labor Standards. And then for questions about the Cook County Paid Leave Ordinance, contact the Cook County Commission on Human Rights. And so again, like, however, if you are in a municipality that has opted out of the Cook County Paid Leave Ordinance, then the state law would apply to you. So that's something that's really important to note, just to keep in mind, whether you're working in a municipality where a local ordinance may be in effect. So some frequently asked questions that we get: does this apply to remote or hybrid employees? And does this apply to employees who work in Illinois but live outside of Illinois, or vice versa? So the department has traditionally found that Illinois workplace protections, so including the Paid Leave for All Workers Act, apply to employees who primarily perform work in Illinois for an employer that does business in Illinois. So, again, that's a very fact-specific inquiry. But we would say if your work is primarily done in Illinois, then, then you would be covered by the act. So how to use paid leave. So employees under the act accrue or earn 1 hour of paid leave for every 40 hours worked. And just note that this doesn't mean 40 hours worked in one work week, but 40 hours total. So if you work 30 hours in 1 week and then you work, 10 hours the next week, that's your 40 hours, and that's 1 hour of paid leave that you have. Under the act, employees can accrue up to 40 hours of paid leave per year. Part-time, temporary, or seasonal workers are also entitled to earn paid leave. However, if they work less hours, then they may not accrue the full 40 hours of paid leave in 1 year. So we have some examples here to just kind of demonstrate some of that prorated leave for those part-time workers. So for example, Kiana works 10 hours a week for a total of 40 hours a month, which means that she earns 1 hour of paid leave each month. So if Kiana works for 12 months, then she would be entitled to 12 hours of paid leave per year that she could use for any reason of her choosing. The second example, Bruno is a seasonal worker. He works 40 hours a week from May to September, and so he earns 4 hours of paid leave each month that he is working. So that's the accrual method of paid leave. And so there is another method that your employer may decide to use because the act gives them the flexibility to do so. And that's called front loading. So that means that employees don't accrue leave, but instead they are provided those 40 hours of paid leave at the beginning of a 12-month period. And so that 12-month period isn't necessarily January through December, and your employer can decide what that 12-month period will be. So for example, it could be based on your hire anniversary date. It could be based on your employer's fiscal year. It could, be based on a number of different things. If an employee separates from their employment, so they quit, they resign, they're terminated before that 90th day of employment, then they may not be entitled to that paid leave to be paid out. Another important thing to note is that your employer cannot ask you to pay the paid leave hours back if you use them and then you quit your employment before the full 12-month period is up. So for example, Powell works at a warehouse and gets 40 hours of paid leave starting on January 1st. On April 1st through the 5th, he takes his full 5 days of paid leave. And then on June 1st, he quits and finds a job closer to home. His employer cannot ask him to pay back his leave. The other thing I did want to note about front loading is that, especially if you're a part-time worker and your employer prorates that amount of paid leave, I would just mention that if you end up working more time than what was anticipated, that your employer has to provide you the additional leave time that you have earned. However, if you work less time than your anticipated schedule, your employer can't take back any of those front loaded hours. So what about those overtime exempt employees? So this, we're talking about managers, professionals, executives, other salaried staff who usually work more than 40 hours each week, and they get paid a salary, so same amount each week regardless of the number of hours worked. They, under the act, they are required to earn 1 hour of paid leave per week. And so even again, if they work more than 40 hours, they will only accrue 1 hour of paid leave. Employers can always allow employees to earn more hours if they have a more generous program. But again, the Paid Leave for All Workers Act sets the minimum standard. So for example, Layla is a manager at a local fast food casual Thai restaurant and is paid a salary, so she does not receive overtime because, again, she's in that management position and meets those exemption requirements. She typically opens and closes the restaurant, which means she works 60 hours a week. Under the act, she would earn only 1 hour of paid leave per week. So when can employees use paid leave? So workers will begin to earn paid leave starting on January 1st of this year, or starting on the first day of their employment, if it's after January 1st of this year. Employees can start using paid leave 90 days after January 1st, which would be March 31st, or 90 days after starting their employment if you're hired after January 1st of this year. Just also wanted to note, your employer may decide to, let employees use paid leave earlier than 90 days, but again, the act provides the minimum standard, so you have to be able to use your leave at the most after 90 days. So frequently asked questions that we get: how does this work for seasonal employees who work less than 90 days per year? So under the act, again, seasonal employees are entitled to accrue their paid leave time. However, they may be unable to use that leave if they stop working before the 90-day waiting period. However, the act does require employers to maintain records on the amount of paid leave accrued, just in case the seasonal employee returns within a 12-month period. So for example, if you have a lifeguard and they accrue their paid leave, but they can't use it because they work less than 90 days per year, if they come back that next year, then that paid leave time that was accrued is still there, and then they can start using it. And again, do seasonal employees have to wait 90 days to use their paid leave every year? And the answer is no. The 90-day waiting period only applies to an employee once during their employment, and that's for everyone. So that's all full-time, part-time, seasonal, on-call, everyone. This waiting period only applies once. And so for that seasonal employee returning the next year, they would be able to use that accrued time right away. So when taking paid leave, employees must be paid at their hourly rate of pay. And so that could be how much you're paid per hour. For those earning a salary, it could be, how much you're earning on a weekly basis divided by the number of hours you're working, etc. So whatever that hourly rate of pay is what you should be getting during your paid leave time. So for tipped workers or employees earning a commission, they must, according to the act, they must be paid at least the full minimum wage. So this is not the tipped wage, this is the full minimum wage for each paid leave hour they take. And so in this, starting January 1st of this year, the minimum wage in Illinois is $14 per hour. But if you work, in a jurisdiction where they have a higher minimum wage, then that's what you should be paid. Employee requests for paid leave. So you can request to use your accrued paid leave or front-loaded paid leave verbally or via a written emailed request. Your employer can have a reasonable policy that requires you to let them know before you take leave. So pro tip, if you do make your paid leave request verbally, such as in person, over the phone, we do really suggest following up with your supervisor or whoever is in charge of approving those paid leave requests in writing. So that could be an email, a text, if your employer has some form you have to fill out. It's just safer so that way your employer doesn't state, they forgot that you requested leave. It's just always a good practice to follow up anything verbal in writing. So here's an example about using paid leave. So Jose's employer requires him to provide 7 days notice for a planned vacation. However, when Jose has to take an unplanned day off, such as when he has to stay home with a sick child, he must notify his supervisor as soon as he is able. And again, under the act, there are some restrictions on how much time or how much notice you have to provide an employer for what they call foreseeable leave. So if it's something like a planned vacation, a scheduled doctor's appointment that months in advance, for example, they can require you to provide at most 7 days notice. However, for that unforeseeable leave, which is, something you wake up feeling sick and or you have a car accident or, some emergency comes up, then, the act allows employees to notify their employer as soon as practical. So under the act, you can take your paid leave for any reason. And so employees do not need to provide a reason for taking their leave. They do not need to provide any documents or proof, such as doctor's notes, in order to take their leave. And an employee can choose whether to use paid leave or any other type of leave provided by the employer or by state law. So in other words, an employer cannot require an employee to use their paid leave for all workers act time before any other paid or unpaid time provided by their employer or state law, and vice versa. So for example, Lee's employer provides unpaid sick leave and paid leave. She wakes up with a migraine and needs to stay home from work. She decides to use her unpaid sick leave in order to save her paid leave for an upcoming vacation. So again, in that case, Lee is the one making the decision. Her employer cannot say, no, you're taking your paid leave time. Again, it's up to the employee to decide what type of leave they take. Can an employer deny a paid leave request? And so under the act, employers are able to deny an employee's request for paid leave, but it must be after following a reasonable and clearly communicated policy. So again, that policy must be in the employer's written employee handbook and distributed to all employees. So, your employer must, outline like whatever the reasons are that they may deny leave, like if there are specific time periods, like busy periods. That way employees know, where they stand and how to plan around for that paid leave time. So here's an example. So Petra's accounting firm has peak season from April 1st through April 16th. In the employee handbook, the accounting firm lets employees know that leave requests will be limited during that period due to staffing needs. And so during that busy season, Petra may deny leave requests per their policy. So, the act allows for employers to deny paid leave requests, based on operational necessity. However, you know, there are certain factors that they should look at, and they should let employees know what those factors might be. Because again, we just want employees to know how to, start planning for some of those, like, planned paid leave, requests that they might be making in the future. So, additional employee paid leave rights. So, another question we often get is, does paid leave carry over? So, under the Act, if an employee doesn't use all of their accrued paid leave during a 12-month period, it can be carried over to the next 12-month period. And so, again, this only applies to accrued paid leave. If your employer provides front-loaded paid leave, that does not have to carry over. Under the Act, an employee is only entitled to use 40 hours of paid leave per year. However, it's up to the employer to decide if they want to allow an employee to use more time. So, for example, Malik earns 40 hours of paid leave in 2024 and doesn't take a day off. So his 40 hours carry over into 2025. He starts the year with 40 hours. He could earn up to 40 more hours of paid leave, but his employer may only allow him to take 40 hours total in 2025. Example 2. Walter works 20 hours per week at a coffee shop and accrues 20 hours of paid leave in 2024. He uses 10 hours and rolls over 10 hours into 2025. So in 2025, he continues to work 20 hours a week and accrues a new 20 hours of paid leave. So Walter now has 30 hours of paid leave to use, which is more than he accrued in the first, year, but because the Act allows employees to use up to 40 hours in a year, he should be able to use all of that time. The payout of paid leave time. So if your employer offers to pay out your accrued paid leave time at the end of the year instead of you carrying it over into the next year, it's up to the employee. So you can decide if you want to accept the payout or carry the time over. If you decide that you want to accept the payout, it has to be in writing, and it would have to be done at the end of each 12-month period. The Paid Leave for All Workers Act does not require your employer to pay out your unused leave if you quit your job or if you are fired. Again, in certain instances, vacation payout may be required under the Illinois Wage Payment and Collection Act. So, for example, if your paid leave time is combined with a vacation bank or some paid time off bank, then that may be required to be paid out. So if you do have a vacation payout claim under the Wage Payment and Collection Act, you can also file a complaint with the Department of Labor. Employer requirements. So there are some record keeping requirements employers are responsible for. So they must keep track of each employee's hours worked, amount of paid leave accrued or provided, and hours of paid leave used and when. And they also have to keep track of your remaining paid leave time balance. And that's something that, should be readily available to employees. It does not have to be on a pay stub, but you can always ask your employer for that time. Employers must also include a written paid leave policy in the employee handbook or employee manual and give the manual to all employees on their first day of employment. Employers must post a Know Your Rights poster about paid leave in a place where all employees can see it. And so you can see here, this is what our Paid Leave for All Workers Act notice looks like. Hopefully you have seen it already in your workplace. It's readily available on our website, labor.illinois.gov/paid leave. So, you can take a look at it there. So how to file a complaint with our office. So when should workers file a complaint? So here are the reasons on our complaint form why, for different violations of the Paid Leave for All Workers Act, such as I took leave from work and wasn't paid for it or was paid too little. I was not allowed to take paid leave from work. I took leave or requested to take leave from work and was fired or punished because of it. My employer did not keep accurate records of the paid leave I am owed. And my employer did not post a public notice about workers' rights under the Paid Leave for All Workers Act. So these are all different check boxes you can mark when filing your complaint. And so here are some things to do before you file a complaint. First, you can always talk to your employer about issues with your paid leave requests, or keeping track of that paid leave time, any discrepancies. Make sure you talk to your employer and see if it's something that can be resolved before getting the department involved. We would also make sure that you get a copy of your employee handbook or manual that has that paid leave policy. Ask to see the totals of paid leave or other leave accruals if they aren't already provided to you. Look at your wage records, your pay stubs, online app to see if you were paid for the time that you requested off. And so, just gather that evidence to submit with your complaint. Because the more details the department has, the easier it is for us to kind of go through. So our complaint form is an online complaint form. There is also a PDF version that you can mail in. However, the online complaint form is the same and it's easy to submit. So here you'll have like your employment information. We will ask for, obviously like your details such as your name, your address, phone number, email address, name of your employer, their address, contact information for them, just so that way we have all of that in our file. And then we ask, what is the job title? What job duties do you perform? If you're still employed by the business, your hourly rate of pay, whether you receive tips, what is the address of your work location? If you're a remote employee, if you're a member of a union, and then again, providing the reason why you're filing the complaint. And then there's a box where you could explain why you believe your employer violated the Paid Leave for All Workers Act. And there we ask like that you provide specific details that would support your complaint. Okay. And so, let's see. And then it'll also be, what is the amount of paid leave hours you believe you are owed? And then if you also believe that these are issues that are impacting other employees in the workplace. And then whether or not you ask your employer to pay you the wages you were owed. And so what happens once you file your complaint? So your complaint is reviewed by a staff member at the department. Currently, the Leave Rights Division only has one employee, so that would likely be me reviewing your complaint. Then we would notify, after speaking with you to make sure we have confirmation on all the details, and if we believe, it merits further action, we'll notify your employer of the complaint. We'll investigate the complaint by speaking again with you and with your employer. We may require your employer to provide additional paperwork and information, again, because we want to make sure we have all the facts and we understand everything, that happened in your complaint. If the department finds that your employer violated the law, we'll notify you and your employer of the decision and offer your employer a chance to resolve the issue. And then if your employer does not resolve the issue, your claim will be sent to a hearing for enforcement. There we go. So what damages are available? So complaints can be filed up to 3 years after the alleged violation. So, clearly the sooner after the violation you file, the better, but you do have 3 years after that violation. So employees, for any violations against that employee, they may be entitled to back wages, compensatory damages, a penalty of between $500 and $1,000, and other relief as appropriate. The department, for any violation of the act, except for the public notice violation, can receive a penalty of up to $2,500. The department can receive, for failure to post public notice, like if an employer fails to post public notice, the department can receive $500 for a first offense and then $1,000 for subsequent offenses. So again, main takeaways. Again, this isn't a paid sick leave law. Instead, it just entitles employees to earn 1 hour of paid leave for every 40 hours worked, up to 40 hours per year to use for any reason of their choosing. If your employer already has a paid leave policy that provides you with at least 40 hours of paid leave that you can use for any reason, then your employer doesn't have to provide you with additional leave time. You do not need to tell your employer the reason for using leave, and you do not have to find another employee to cover your shift. Your employer may deny a specific leave request, but they must have a reasonable policy explaining why. So you can always submit questions. For example, if there's something that you think about after this presentation, you can always send an email to us at dol.paidleave@illinois.gov. You can always visit our website at labor.illinois.gov/paid-leave. We have a frequently asked questions tab for more information about the act. So that is it for my presentation. And so it looks like we have one question that says, what if the employee handbook says paid leave can be denied for any reason? And so I know the act says, your employer can deny leave for operational necessity. And so, but your employer kind of has to define what that is. So again, if it's a busy period, if it's a peak season, reasons that they might deny leave. But, I think we would have to look at that policy because, again, we want to make sure that employees are given the opportunity to use their 40 hours of paid leave. And so, that might be something where we would have to look at all of the circumstances, especially if someone isn't able to use all of that paid leave time. Let's see, it looks like we might have another question coming up. Oh, maybe not. So it looks like we might not have any more. Oh, here we go. Someone asked, can we change paid sick leave to just paid leave? So it depends. And so again, if you have paid sick leave, your employer provides paid sick leave, but no other leave, then that would likely not be in compliance with this act because, again, typically sick leave, has more restrictions. You can only use it for when someone is sick or you have doctor's appointments or things of a medical nature. However, employers, can decide that they want to offer paid leave in addition to paid sick leave. Because again, nothing in the act prohibits employers or discourages employers from maintaining those, policies that they have in place currently and then providing this leave. So, with this new act, it doesn't mean that your employer has to get rid of paid sick leave, but they could decide that in addition to paid sick leave, they're providing this leave. So, again, so long as employees are receiving those 40 hours of paid leave that they can use for any reason, then we would see that policy being in compliance with the act. Are there any other questions? I know that this is a lot of information to take in, and we're always happy to receive questions from everyone. Just be patient with our office because, as I stated, currently I am just a division of one. So, please be patient if we take some time to respond to your email or to your phone call. But please let us know if you do have questions about whether your employer's policy is in compliance with the act, or if you have questions about how this act may apply to you. Again, if you work in the city of Chicago or in suburban Cook County, please reach out to the Chicago Office of Labor Standards for questions about Chicago's paid leave ordinance, and then reach out to the Cook County Commission on Human Rights for questions regarding the Cook County paid leave ordinance. I think, if you have additional questions, please, email us. As I stated, be patient if it takes us some time to respond, but we are doing our best to respond to everybody. Also, feel free to visit our website. We try to update our FAQs. We know we have the posters that are up, but in case you do have, some questions, it might make sense to check out the FAQs in order to make sure